Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to our Curious Amalgam. I'm Barry Nigro, and the title of today's episode is What Happens When Competition and Geopolitical Issues Intertwine? Surveying the landscape of the global semiconductor sector. In this episode, we'll be discussing issues related to competition and geopolitical concerns in the global semiconductor sector. In particular, we'll be looking at the Chinese regulatory authorities' approach to merger clearance and how American and European lawyers may want to approach deals requiring clearance in China. My co-host today is Alicia Downey. Alicia, would you like to introduce our guest and kick off the conversation?
Thanks, Barry. It's my pleasure to introduce David Emanuelson, a Washington, D.C.-based antitrust practitioner at the law firm of Arnold Porter. From 2017 until he joined Arnold Porter in the fall of 2023, David was Intel Corporation's chief M&A regulatory counsel. He is one of the few antitrust lawyers outside of China with significant experience directly interacting with China's State Administration for Market Regulation, which we'll call SAMR, which makes him the perfect guest for today's discussion. Welcome to our Curious Amalgam, David.
Thanks, Alicia. Great to be here.
For listeners who may be less familiar with merger clearance agencies outside of the U.S., what exactly is SAMR? What do they do?
So SAMR is the antitrust authority of the China regulatory regime. It actually is a recent creation. It was formed about 2018. And back before then, there were a number of antitrust authorities, each looking at different aspects of the law. And so they decided to consolidate it several years ago.
So how did it come about that you're an American lawyer, you're in-house at Intel? How did you come to get so much experience before SAMR?
Yeah, so that is, it really is the privilege of working in-house, working for a company. And it's one of those things that I already miss being on the outside. But when you're at a company, most of the competition authorities, they really want to hear from the representatives of the company. And so I used to, whatever antitrust issue I was working on, I would go to, whether it was the European Commission, FTC. But SAMR had specific rules where if you were not a Chinese qualified lawyer, you could not actually even appear in front of the competition authority. And so I feel like that experience is somewhat valuable, and it's why I'm here talking to you all today.
David, I'm curious how SAMR's standards for reviewing mergers compares to other jurisdictions. For example, here in the U.S., we've seen a lot of discussion about the neo-Brandesian movement and attempts to move away from the consumer welfare model toward an analysis that takes many non-economic factors into account. Does SAMR use a similarly broad analysis, or are they, more focused?
Yeah, it's quite broad. It's probably the kind of the joy and the challenge of when you have either an investigation or you have deals that they're reviewing. It's actually written into the law.
Yeah. What sort of things do they take into account?
So they have, if you actually look at their anti-monopoly law that's on the books, they have those common concepts that we think of as U.S. antitrust lawyers, protecting consumers, efficiencies, innovation. But then they also have this language at the end of their law that talks about promoting the healthy development of the national socialist economy. And that is unique, right? It's explicit in their law that they're going to be thinking about other factors besides what classically you think about in antitrust as a U.S. lawyer.
And how do you manage that or anticipate, those factors and how they might play into a merger review when you're signing up a deal? A lot of times when companies are putting deals together, they're trying to predict how long it will take to get cleared, whether it will get cleared, what sort of remedies might be required? How do you manage that as an in-house lawyer, given the...
Yeah, you can draw upon some first principles as a Western trained lawyer. If you were trying to get a deal through the FTC or the European Commission, you think about who would complain about the transaction, what support you're going to get. And you usually think about it from a customer perspective, getting the customer support, but then also competitors that might complain and foreclosure impact. And so it's similar in China, right? You're thinking about who are the stakeholders that might either take an issue with the transaction or see an opportunity out of the transaction. And you want to get their support. The difference is it's just a much broader set of stakeholders. And it's different than what you would think about as a U.S. lawyer.
We're in a global economy. A lot of deals are global transactions, and it's not unusual to trigger filings in multiple jurisdictions in addition to the United States. Is there any read-through as to what SAMR is likely to do based on clearances by other, I'll say, ex-US jurisdictions?
Yeah, this was the thing that when I worked at Intel, being able to coordinate a transaction globally, also knowing that China was probably the most important jurisdiction and the interaction of jurisdictions. So there definitely is some interaction. I would say a good rule of thumb is that if you have an issue in the US or Europe, you're likely going to have some variation of that issue in China. I think the difference, though, is that just because you don't have an issue and maybe you get through a transaction without a second request with phase one clearance in Europe, it doesn't necessarily mean you're home free in China, because they're going to look at it from a different perspective. And so there's a number of examples of major transactions that, got through unconditionally outside of China, where China was the only remedy.
Now,
or may not have been approved. Sorry.
Now, our title promised that we'd be also talking about geopolitics as well as competition issues. What kind of geopolitical pressures are at play from the Chinese perspective, specifically when it comes to sensitive technology like semiconductors? Questions like what organization might direct, either tacitly or expressly, the Chinese response to those types of pressures, whether they're self-determined by SAMR or influenced by other bodies or individual high-ranking officials within the Chinese government.
Yeah, so front and center right now in the semiconductor industry, and of course other industries that might have similar national security concerns, are export controls. So I think the most challenging and gratifying aspect of working in a major company in this area is being able to learn and see the intersection of what was going on with the geopolitical tensions and how that impacted merger review in China, because there definitely is an impact. The second part of your question, there's an assumption built in there: who's directing SAMR, who's running the show. I want to use a phrase that I learned from another lawyer. I'm going to give a shout out to Drew Foster at Skadden, because he was someone that really, really helped teach me on things. And it's a consensus-based process. So that's something that I've learned very much through the years. You can't think that there's one person, there's one entity running the show. There's a lot of voices in the process, and it's consensus-based. So just like I said, you have to line up as much support as you can get for your transaction, and across a variety of stakeholders.
So we talked earlier about the potentially broad scope of SAMR's analysis when doing merger reviews, and you brought up semiconductors. Just focusing on that industry in particular, which you know well, are clearance decisions purely driven by the economic analysis, or if not, what sorts of considerations in particular come up in the semiconductor industry?
Yeah, economic analysis has a role to play. There's no doubt. And oftentimes SAMR will hire its own economists to help review transactions. And it would be good if you're a merging party to also have your own economist to make those arguments. So that's part of it. The geopolitical issues are definitely part of it, the stakeholder impact. The one thing I'll say is there is a bit of a cynicism on the side of a lot of lawyers in the United States that it's all geopolitics, that it's all a black box, that there's really nothing that you can do within your control. And that's not necessarily the case. Really what your job is as a classic antitrust lawyer is to work through the process, put yourself in the best position so that you can take advantage of geopolitical opportunities. Because what you don't want to have happen is, the waves of the geopolitics come through and there still be process issues that are open. And so your job as the antitrust lawyer is to deal with the process, make the good arguments, get the information to the authorities, because you certainly don't want to miss any windows.
Since you brought up process, I'm curious, how does the process compare to our process here in the U.S., where sometimes transactions are involved in a second request review, lots of documents, lots of interrogatories, depositions, and so on? What is the SAMR process like that or different?
Lots of information requests, I will say that. Document requests too. I wouldn't say it's as like a second request situation. I will say it's probably more like the European process than the U.S. process. I do think that now that there is the stop the clock mechanism under the revised regulations, information requests will be a tool for the authorities to utilize that mechanism.
What is the stop the clock mechanism?
In an ordinary review of a deal, there's 3 phases. Phase 1 is 30 days. Phase 2 is 90 days. The last phase is 60 days. And it was just, in the old regime, you would just count the calendar days. And then once you got done with 180 days, if you didn't get approval, unless you wanted to walk away from the deal, which most parties don't, then you just do a pull and refile and you start another 180-day clock. Under the new regime, I think there's a recognition that's probably not a good process. And so there's an ability to issue an information request. If the parties don't respond in a timely manner, you can stop whatever phase you're in, and the clock isn't running anymore. And that's similar to what happens in other jurisdictions.
So does that mean parties sometimes use that strategically to stretch out the time?
I've never been a part of a transaction where the parties want to stretch out the time.
Okay.
But it could be the other way around.
Okay. What deals are you watching at the moment that you think American or European lawyers should be paying attention to?
One thing I'm really watching to see what other transactions are going to be announced. I think overall the environment has been less deal focused in this area. Watching to see what other transactions are actually going to come up. I guess the other thing I'm interested in is, when is SAMR going to finalize another aspect of the revision of the merger regulations that impact the filing thresholds and also give it some new mechanisms to call in transactions that don't hit the threshold. I think those are areas that I think will impact the enforcement environment.
And so looking at it from a practical perspective, if someone out there listening is an in-house counsel contemplating a merger that will require clearance from SAMR, what's some practical advice that you would give them, or perhaps even just the one thing that you'd like them to take away from this podcast?
Yeah, I think as an in-house counsel, your job is to translate all the noise that's out there and be as concise you can about the risks to your executive team. Because ultimately they're looking to you, not your outside advisors, about saying, should we do this deal or not? And you have to be at some point you have to make a call on what you see the risks are. And so I think that's the area where at some point you have to make the call.
Thanks, David, for that. The other thing I want to just, as we come into the home stretch of our conversation with you, is to advise listeners that we're going to post a link on the episode webpage to an article that David wrote, one of a few articles that he's written regarding tech M&A enforcement. It's in the spring 2020 issue of the section of Antitrust Law's Antitrust magazine. It's called The Potential Chilling Effects of Lowering Standards for M&A Tech Enforcement. So for people who want more information about the kinds of things that David has been talking about, and not even specifically limited to China, is that right, David? This is a broader article?
Yes,
Great,
exactly.
then you can look at that material. And now I'll turn it over to Barry.
Thank you, Alicia. David, before we let you go, we'd like to get to know you a little better as a person. Based on your experience in-house at one of the biggest tech companies in the world, what advice do you have for young lawyers working with in-house counsel at large companies on sophisticated regulatory matters?
Sure. This is a common piece of advice, but I believe it in my soul. And it's about investing in learning your client's business. There's a lot of great lawyers out there, but what you really want, what you value, are people who know your business, people who take the time to go that extra mile and really learn it. And don't be deterred by the fact that there's limitations on your access to information. I'm already sad that I don't have access to all the wealth of information that I had working inside of a company. But what you want to do is show that investment of time and commitment, because there's going to be a mutual investment on the other side, right? If you're looking for outside counsel, you want to see someone who's committed, and you're going to take the time to spin them up, because that's the kind of, you can only really get that trusted advisor status if you truly know the business of your clients.
Interesting. So, David, tell us something interesting about yourself that we wouldn't know if we knew you only professionally.
A couple things.
Nope, just one thing.
Oh, no! All right. I played college golf. I played on the golf team in college.
What was your handicap?
I was better than a scratch.
Oh, wow.
Was this one of those colleges that had
you,
like a varsity golf team? Is that?
There's lots of varsity. Come on, there's lots of varsity teams out there. Where do you think Tiger Woods came from?
Shows how much I know about golf.
Yeah. No, I think it's one of those things where it took me a while to get those competitive juices back. But now that I'm at a law firm, now I'm re-experiencing what it was like.
You might be too competitive. You can't beat the clients, David. That's not good.
You can beat Barry and the other law firms.
Okay.
Working for the business.
Did you ever have a double eagle?
No, I never had a double eagle. No, I never did.
All right.
That'd be
for those
good.
people who know what that is, maybe you could either take comfort in that fact or not. There's one more thing we're going to do just to round out our program, and that is we're going to play a little game we call the Curious Hat.
And now it's time for the Curious Hat.
The rules of the game could not be any simpler. David, we're going to draw a random surprise question from a non-existent, purely virtual hat and read it to you. So here's your question. You have been offered a free ticket on the next space shuttle flight. Do you accept it or not? And why?
Yeah, I accept it. That's a once-in-a-lifetime opportunity.
It might be the last thing you ever do.
Oh, come on. I believe in technology. I'm a technology lawyer, right? I look at everything that's happening in the world that's based on things. If you had any idea what it takes to make an advanced semiconductor, I think it would probably make the space shuttle flight look like child's play. And yeah, of course, I trust all the engineers, and I would go right up there to see the world. That's
a great answer. Thank you for being a wonderful guest on our Curious Amalgam. Thanks to co-host Barry. Thanks to the listeners. Everybody tune in to the next Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.